All right, welcome back to the Daily Facts, and we're picking up with the Jussie Smollett case. This is part 4. So yesterday we went over part 3, and these are the points that I thought were pretty important. The CCSAO, that stands for the Cook County State's Attorney's Office. So when you see the acronym CCSAO, just know that that is the Kim Foxx office. Engaged in a substantial abuse of discretion and breached its obligations of honesty and transparency by making false and/or misleading statements to the public regarding the nature and reasons for the dismissal of the initial Smollett case. The initial Smollett case did not fit the criteria for the CCSAO's chief data officer used to identify the cited 5,700 figure because all of those cases were referred to a diversion program. There were not thousands of, or arguably any, similar cases. So he's essentially saying there weren't any similar cases. The CCSAO and State's Attorney Foxx made false public statements representing that 10,000 was the most Mr. Smollett could have been ordered to pay in restitution under the law when there is no such cap under the provision. So there's no cap. It could go to 10 million, it could go to 100 million. There's no cap. It doesn't stop. Mr. Smollett has a prior misdemeanor conviction out of California from September 22nd, 2007 for DUI, driving without a license, and giving false information to the police. So it sounds like he has a history of giving false information. He was placed on 24 months of probation. Okay. And lastly, I thought it was important to know that State's Attorney Foxx recused herself. Okay. That in and of itself is pretty fascinating to me. But for some reason, she still kind of was lingering and hovering over the case. All right, so we're going to pick up on conclusion 4. The OSP did not develop evidence that would support any criminal charges against State's Attorney Foxx on any individual working at the CCSAO. While the OSP evaluated any and all potentially applicable criminal statutes, the OSP focused its investigation on criminal statutes that might be implicated if anyone involved in the handling or resolution of the initial Smollett case had received an improper personal benefit or obstructed how the case was handled. For example, the OSP, Office of Special Prosecutor, considered bribery, and this is the statute 720 ILCS 533-1, failure to report a bribe, 720 ILC 5/33-2, official misconduct, 720 ILC 5/33-3, obstruction of justice, 720 ILC 5/31-4, and perjury, 720 ILC 5/32-2. Based on the voluminous documentary evidence gathered and witness interviews conducted, the OSP did not develop evidence that would support any criminal charges based on bribery, failure to report a bribe, official misconduct, obstruction of justice, perjury, or any other criminal statute. It is important to note that under the law, a person can only be convicted of a crime if the prosecution proves all the elements of the charged offense beyond a reasonable doubt, including, where applicable, proof of any criminal intent. Further, under applicable ethical standards, the OSP, as a prosecutor, must act in good faith and should never pursue a prosecution for criminal charges that the prosecutor cannot reasonably expect to prove beyond a reasonable doubt by legally sufficient evidence at trial. It's good to know. Thus, under these standards, the OSP cannot seek criminal charges against State's Attorney Foxx or any CCSAO employee without developing substantial evidence of a crime. Based on these legal and ethical standards, the OSP did not develop any evidence to support any criminal charges against State's Attorney Foxx for any CCSA or any CCSAO employee. Okay, well, I don't know. I mean, he's the attorney, right? So he would know, but just in my humble opinion, I think that what she did was, I mean, he's saying it's unethical, and it definitely is. I don't know. It's questionable to me that it's not criminal, but I'm not the attorney, so we are going to go with what um, Mr. Dan K. Webb, the special prosecutor, has told us here. All right, conclusion 5. The OSP did not develop evidence of improper influence by any outside third parties in the decision making by the CCSAO in the initial Smollett case. Now, this is interesting because there was a lot of talk, and people were, saying, well, he was talking to the sister and Michelle Obama's attorney when she was at the White House, and so on and so forth. Well, the OSP is telling us here that there wasn't any improper influence. Okay, so we must take him at his word. All right, let's read this. State's Attorney Fox is an elected public official who heads an office tasked with protecting individuals and society and empowered with the authority to change people's lives through the prosecutions and pursues. Therefore, State's Attorney Fox and the CCSAO must be accountable to the public. Being accountable to the public means State's Attorney Fox and the CCSAO must also be accessible to the public, including to answer questions and provide information when appropriate to people impacted by the criminal justice system, including victims and victims' families. State's Attorney Fox and the CCSAO also must be receptive to criticism or concerns raised by constituents or people impacted by the criminal justice system regarding criminal cases in Cook County. Accordingly, it is wholly proper under certain circumstances for the state's attorney or others at the CCSAO to speak with individuals concerned about how a particular case is being handled or how the CCSAO approaches or resolves cases generally. Okay, so that makes sense. They should be available to the public. I mean, after all, you're prosecuting, and ultimately you are changing lives. Whether a person is put in prison or not, it's still a lot to go through. Family has to pay for a defendant to have that person defended. There's a lot of stress on the family. It separates families. I mean, there's a lot that's involved when someone is indicted, brought up on charges. And, it's important for the state's attorney to be available, or the people in the office at the very least, to answer questions. And I think that's fair. Following the dismissal of the initial Smollett case, including the CCSAO's public release of emails and text messages in response to Freedom of Information Act requests, there was speculation in the media that conversations State's Attorney Fox had in the weeks following Mr. Smollett's reported attack improperly influenced or impacted how the CCSAO prosecuted or resolved the initial Smollett case. As a result, the OSP investigated whether any such communications resulted in any criminal conduct by State's Attorney Fox or any other individual working for the CCSAO relating to the initial Smollett case, including bribery or official misconduct, and whether State's Attorney Fox had any communications that could be construed as influencing how the CCSAO decided to prosecute or resolve the initial Smollett case. Based on public allegations against State's Attorney Fox and evidence the OSP developed relating to communications she had about the initial Smollett case, the OSP officially focused its investigations on communications State's Attorney Fox had with 3 people. Okay, so this is interesting. The first person is Cheryl Lynn I'm going to slaughter this. Ifill. So it's Sherry Lynn Ifill, President and Director, Counsel of the NAACP Legal Defense and Educational Fund, Inc. Christina M. Tina Teschen, CEO of Time's Up Now, formerly Michelle Obama's chief of staff. Okay, so there it is. She was the chief of staff. And Janae Smollett, Mr. Smollett's sister. Okay, so this is going to answer those questions. Let's get into it. The OSP did not identify evidence indicating that the State's Attorney Fox's communications with these people influenced or impacted how the initial Smollett case was prosecuted or resolved. Let me just rewind a little bit, because don't forget, early on, let me get out of that. Early on in this report, it said that there's a 60-page evidentiary report. Okay, and that is not for public consumption at this moment. But the special prosecutor, Mr. Dan K. Webb, wants to make that public. And I would imagine that if there are text messages and emails and such coming from these three individuals that we just talked about, Janae, Christina Shen, Janae Smollett, and Sherry Lynn Ifill, that will become public. If he gets his way and the judge approves, then we'll be able to see that. It's a 60-page document. It's a 60-page report, rather. All right, so let's move on, including the CCSAO's decision to dismiss the case or the terms of the dismissal. In fact, based on the evidence developed by the OSP, State's Attorney Fox did not have any substantive communications about the initial Smollett case with any of these people after Mr. Smollett was charged. However, conversations with these three people did deepen concerns State's Attorney Fox had regarding information being released to the public, seemingly by the CPD, about ongoing investigations. Thus, communications with these three people spurred her to reach out to CPD Superintendent Eddie Johnson. That's the Chicago Police Department's top police officer, Eddie Johnson. He's no longer with the CPD. He was fired by Mayor Lightfoot of Chicago. But I digress. To recommend the case be referred to the FBI, an action that was not improper and did not have any impact on how the case was investigated or ultimately prosecuted. Furthermore, while the OSP focused on State's Attorney Fox's communications with the three individuals noted above, OSP did not identify any other people that had any improper influence over the prosecution or resolution of the initial Smollett case. Okay, well, that's a mouthful, but I get it, and I'm sure you folks get it as well. So those three people, they didn't find any issues, and they didn't find issues with anyone else that that Kim Fox was communicating with during this time. All right, let's move on. Discussions of the OSP's three final conclusions and supporting findings related to the conduct of the CPD in the initial Smollett case. In the course of its investigation, the OSP learned of allegations that anonymous CPD employees improperly disseminated law enforcement sensitive information concerning the original Smollett investigation to media sources while the investigation was ongoing. So that's what's called leaks. Therefore, the OSP undertook an investigation to determine whether wrongdoing occurred relating to any alleged CPD leaks and has reached the following three major final conclusions as to the CPD. Okay, the OSP did conclude that the majority of CPD media communications during CPD Smollett investigation were authorized communications in accordance with CPD's written policies. Two, the OSP did conclude that there were media reports that contained unauthorized leaks of police investigative information by CPD personnel that were in violation of CPD's written policies. However, for reasons set forth below, the OSP was unable to identify the anonymous alleged CPD sources of such leaks. And three, the OSP did not develop evidence that would support any criminal charges against any individual working at the CPD. Okay, so basically to sum it up, the Chicago Police Department did leak, but because it was anonymously done, there isn't anything that the special prosecutor can do. And that concludes that. All right, so we're going to leave it there and pick up tomorrow on part 5. We're almost done here, but I think this is thoroughly interesting. So thank you for stopping by the Daily Facts, and we'll see you again soon. Bye.